biggest differences in the home. Okay. We usually start. So when it starts, usually we usually do it on and then have you ever done?
Yeah.
I think it's a lot of fun. It's a lot more fun than yeah, it's fun. It's hard on a weekend. On a weekend, you know, you start on Saturday at 6 o'clock. We leave at 5 p.m. And it gives us time to go on our seats. Where do you live in this community? Just take a cab. Where did you park?
We parked, is it Bethlehem?
Yeah. Glendale's more than if you can't park on the west side of the state. You know, they keep this really, so it's close to the, it's a lot right there. Josh and I just sort of missed that. This is.
Yeah.
Yeah, it's, you know, it's better because it's on the west side, so it's right in the highway. But it's still. Show me, let me bring it up. Show me, this is the record. Thank you. Please be seated. We're here in our cause number CACV120849 involving Sage Advice Investments LLC versus Charles A. Harrison. This is the time set for oral argument. Each side will have 20 minutes. Appellants, if you'd like to reserve time, we will let you manage your clock, which is at the podium. We are audio taping as well as videotaping this. So as you come forward, please identify yourself and your client, because it's more likely we'll listen to the audio tape. I think videotaping is going to YouTube and people are putting it to music. So we'll see how that all works out. I didn't know that there was a big demand for oral arguments at the Court of Appeals, but
Judge Portley will be going viral.
whoop, whoop. So we will, with that, identify yourselves. We've read the briefs in this matter. We have conferenced this. We understand the issues. And with that in mind, Mr. Wintberg?
Thank you and good morning. May it please the court, Mark Wintberg and Michael Stansavich on behalf of the appellant Charles Harrison. We'll try to reserve about 5 minutes for rebuttal. This is an appeal from a judgment entered in a breach of contract case. And while the issues all revolve around a non-judicial foreclosure sale, this is not a typical deficiency case. In a typical deficiency case, the only issue before the court is going to be payment or non-payment. If a note is not repaid, the lender is going to be entitled to judgment. This case is different because the parties negotiated a contract that required Sage to conduct a trustee sale before it was allowed to file a lawsuit. Sage was not entitled to judgment unless a valid trustee sale was conducted. Because of that provision in the contract, Sage had to prove that a trustee sale was conducted. Not only was the validity of the trustee sale a relevant issue for trial, it was an element of Sage's case in order to get a judgment. Because of that, the notice and the description of the trust property were issues that should have been addressed at the trial court. We know that the notice, the only evidence on the trial court record is that notice was not sent to the correct address, which was the address that was listed in the deed of trust.
But isn't there also evidence that on the return slip, and I forget the technical name for it, that had the correct address?
There was a return receipt that was produced by Sage at this stage. It was not on the trial court record, or it wasn't presented at trial. That was used in response to a motion for summary judgment that was filed previously. The motion was denied. That evidence was never presented at trial, so Harrison never had the chance to respond to that at trial. We do believe there are foundation issues with the return receipt, and also the return receipt, if you look at it, Sage wants you to consider half of it. They want you to consider the handwritten address that was listed on the receipt. They don't know who wrote that address. They don't know when it was written. They don't know why it was written. They don't have a forwarding order from the postal service saying that mail was forwarded. So that's issue as to the foundation. But also, the return receipt shows delivery on January 31st, which is well beyond the 5 days that the notice of sale had to be mailed to the trustor.
Was this raised in response to the motion for summary judgment? Did your client challenge it on that basis?
We did object to it at that time in their statement of facts. And then from that point, the court denied the motion for summary judgment, gave some oral reasons on the record, but that issue was never actually litigated at trial. We don't believe the issue was ever resolved. The denial of the motion for summary judgment just means there are some issues to resolve at trial. And the fact that it was never readdressed at trial means that it's an unresolved issue.
Were you required to file a counterclaim in response to the complaint in order to put the issue in front of the court?
In this case, no, because there was a contractual term
Okay.
that said the trustee sale must be conducted.
So the burden was on the other side, not yours.
Precisely. They were obligated to prove that they were entitled to judgment under the contract, and that contract required proof of a valid trustee sale.
And so that required the right address and the right, and the right timeliness. And
Precisely.
And the right legal description.
Correct, that's our position. And both of those issues void a sale. If the notice isn't proper, or if the legal description is not proper, then the sale is void. So without
How
evidence.
about if it's 5 days late, would that void the sale? Assume it was correctly addressed, but was just a couple of days late, would that void the sale?
I'm not sure that I think that's an issue that the trial court would have to address, is to determine whether that's sufficient notice, or whether, I think that not strictly complying with notice voids the sale under our Supreme Court case law. So there's certainly an argument that the sale is void under those circumstances.
Well, is the sale void or is it voidable? Because the Supreme Court's talked about that distinction as well.
Sure, and I think the failure to provide notice voids the sale. It is void. I know there are other reasons that a sale is voidable. And then moving to the legal description of the property, if you look at Trial Exhibit 6, that's the warranty deed from Sage to Harrison, originally conveying this property, the property that was ultimately foreclosed. That warranty deed says Sage is conveying a 50% interest in the property that was on Exhibit A. It's the same Exhibit A throughout. So that explicitly said 50% is being conveyed. But if you look at the notice of sale, all that's listed is the property on Exhibit A. There's no notation that only 50% of that property is being conveyed. So by looking at the notice of sale, it's not possible to identify the trust property, and for that reason also, the sale is void.
Are you suggesting that there would have been different bidders, or is there something about this property that makes 50% of it marketable, or 100% less marketable, or?
We don't know because it wasn't done. I think a smaller parcel of property is more appealing. It fits the budget of more buyers. So it is possible that could have had an effect.
But isn't it also a 50% interest? You're a partner with somebody in the property?
I'm not sure how that would work. I think you would get a division of the property at that point, not being true tenants in common.
But is it an issue of whether there's any harm by these technical deficiencies that you're arguing? Is the issue whether there was any harm by these technical deficiencies, or is it simply you have technical deficiencies, you don't get to do what you did?
It's both. Because there are technical deficiencies, the sale's void. However, there was harm because there's a statutory right to have 90 days notice of a trustee sale to do whatever it is that you may want to do. He could market the property and try to sell it short of a trustee sale and get a better price. There's a number of things that could have been done, and the statutes don't require a showing of some particular harm. The harm is the violation of the due process rights, losing a property without notice.
But assume he got notice of the sale. Assume it had been correctly addressed to his post office box. Would the deficiency in terms of the description of the property, would that still be significant?
That is significant because there's an inaccurate record in the public record right now.
I guess a better question is, does he not have an obligation to challenge the sale? If he's on notice of it, wouldn't that be something that the burden would at least shift to him to go in and challenge the sale?
The description of trust property is one issue that's not waived. If it's incorrect, it can be set aside even after the sale. So if there's an obligation.
What's your best authority for that?
I believe it's within the statute, 813E, Yeah, I'm going to have to check that statute, but the statute that discusses the description of the trust property and that the trustee shall set or cancel the sale if the description is not accurate. If there are no other questions, I'll reserve the remainder of my time.
Okay, thank you.
Good morning, and may it please the court. Milton Wagner on behalf of the Appellee Sage Advice Investments. There are some matters here that are not in dispute. It's undisputed that the appellant owes my client over $800,000. It's undisputed that the appellant has no intention at all to pay that debt. It's undisputed that my client had the right to conduct a trustee sale in order to help recoup some of the damages resulting from the appellant's default.
I certainly agree that the indebtedness and the non-payment puts a lot of equities onto your side, but isn't your side obligated to dot the i's and cross the t's?
And, Your Honor, in this case, the evidence is that the notice that was provided by the mailing went beyond what is actually called for in the statute. The statute only calls for the mailing of the notice. In this case, we have evidence that the notice was in fact delivered to the P.O. box that's set forth in the deed of trust.
And what is that evidence?
The evidence comes from a return receipt that is supported by an affidavit of the trustee indicating that that return receipt was received in response to the mailing. Within the return receipt, we have a signature by a man identifying himself, a man named Mike Easterday. And we know from the evidence that Mr. Easterday signed for at least four documents, legal documents relating to this dispute that were sent to Mr. Harrison. We know that Mr. Harrison was traveling in Brazil at the time of these events. We know that Mr. Easterday was living in Mr. Harrison's house at the time of these events, and again, that he had signed for all of these documents.
Was there an evidentiary hearing where the court made findings establishing these things you've just said?
There was a motion for summary judgment presented by the plaintiff, the appellant, in which they made all the same arguments that they're making here. In response, we presented the certificate from the U.S. Postal Service that was supported by an affidavit, and it's completely appropriate in the context of a motion for summary judgment to present the evidence that way. The trial judge denied the motion. He stated the explanation for his ruling on the record. A couple of weeks later, we had, at the time set for trial, there was an oral motion in limine by us to not have the trustee come in light of the court's ruling on summary judgment. The trial judge agreed, and we proceeded with the evidentiary hearing.
So in essence, your argument is that a denial of a motion for summary judgment affirmatively established your facts.
The plaintiff brought a claim, brought these arguments, presented the evidence. There was evidence presented in response to that. The court ruled that there was no genuine issue of material fact for trial, ruled in our favor, and then entered essentially an order in limine as a result of that motion.
So the court made a credibility finding, though, without giving him an opportunity to testify that he didn't receive, or put on his witnesses to say this never was in our P.O. box. Is that problematic?
Not in this case, Your Honor. They had the opportunity to present whatever evidence they wanted to present to the extent that Mr. Harrison was going to testify to that. He had an opportunity to do that by affidavit in connection with the motion for summary judgment. And, you know, in connection with the order on the oral motion in limine, Judge Gama gave the plaintiff an opportunity to submit an offer of proof as to whatever evidence the plaintiff would have submitted on this issue. It's not really discussed in their brief whatever that exchange, but the record shows that they would make the same arguments that they were going to make on the motion for summary judgment and had no new evidence.
So, make sure I understand. The court, in denying the motion for summary judgment, otherwise said that the issue of notice was resolved, and there wasn't a genuine issue of material fact with respect to that dispute.
That's correct, Your Honor.
So the only thing really that was really going forward was the description dispute?
The description dispute was addressed on summary judgment as well, Your Honor. Both of those issues were raised, discussed, and decided at the summary judgment stage.
The only thing that was tried was the adequacy of the price?
That, not just the adequacy of the price, but also the amount of the deficiency. So the uncontroverted evidence is that the mailing was readdressed to the P.O. box that's set forth in the deed of trust. It was delivered there, and there was no evidence presented or offered, suggested in an offer of proof that the information in the certified mail receipt is inaccurate.
How about the timing?
Your Honor, the timing issue was raised for the very first time in the reply brief on appeal. It appears that we had included a footnote in our response that this issue wasn't raised below, and it appears that the reply picked up on that and tried to make an issue of it. But anyway, it wasn't raised below. It's been waived. Had it been raised below, perhaps we could have had the Postal Service come in and provide testimony, but that issue's been waived, Your Honor.
What was the trial court's ruling then on the description of the property?
That it met the requirements under the statute.
But it acknowledged that it failed to specify that it was a 50% interest.
I don't think it said that it failed to. I think it said that it was not required to. And let me address that issue, Your Honor. So there's a 50% interest here. My client held the other 50% interest, and it's not. It was suggested that it's sort of part of the land. It's not. It's one piece of land, two parties that own equal interests in that one piece of land. So it's not a matter of describing some parcel of a bigger piece of land.
Parcel A and parcel B, you don't have that.
Right, correct. There's parcel one and only, and two parties hold an interest in that. The evidence is that there were no bidders at the trustee sale other than my client who submitted a credit bid. And essentially what the appellant is arguing is that the trustee should have put a description in the notice of sale that would have been likely to lead to a smaller market for the trustee sale, smaller market of bidders. We know that from my client was the only party that had an expert at the trial, and we presented evidence that there would be a smaller market as a result of the 50% interest. So they're asking you to cut 0 other bidders down below that. But the law doesn't provide for that. What the statute provides for is providing a legal description of the property. And the appellant essentially argues that a legal description means more than just describing the property and goes into describing the interests of whatever parties throughout history may have an interest in that property. And the statute just doesn't provide for that. When you look at ARS 33802, it talks about how to set forth a legal description. In that context, it talks about it in a deed of trust.
But isn't it kind of a common sense interpretation, though, if, say, you only have a 1/1000th interest in some property? Isn't that pretty significant in terms of who may be interested in buying property? And if the point is to notice a sale, it seems like there would certainly be some cases where it would make a difference. I don't know whether it does here, but
It doesn't, Your Honor, and the reason that it doesn't is that we have a recording statute that requires all parties who wish to hold out their interest in a property against third parties to record that with the county recorder. And so what the trust statutes provide, they don't say anything about interest. They say describe the property. Prospective buyers then go do the due diligence and figure out what the ownership shares are. And so you may have all types of ownership interests. You may have life estates, reserved life estates, you may have partial interests, you may have easements, etc. And there's nothing in the statute that would require a trustee, who does not have to be a lawyer, to try to go and sort of figure out who all the interests are and then put that in the notice. There's no precedent for that.
The trustee would have a policy of insurance which would technically outline all of the interest in the property.
That possibly, I don't know that they're required to under the statute. I think that is common, that it occurs that way. But I don't believe there's any requirement in the statute of an insurance policy. But in any event, it goes beyond what the statute provides to require a trustee to do that. And it's completely unprecedented. In fact, both sides looked to try to see if we could find any precedent for what they're arguing here. The best that the appellant could come up with is a case from the Maryland Court of Appeals in the Fisher case that's cited in the brief. In that case, the trustee had noted that there was a partial interest being described in the trustee sale. The debtor in that case challenged it as confusing and misleading, and that's what, frankly, I think you would expect, that when somebody's describing something as smaller and lead to a smaller market, that's when you would complain. We have the opposite of that here. But the court upheld the sale, holding that the debtor didn't show that the description was prejudicial to the sale. So they didn't say that that's the way to do it. They said it was okay in that case, no showing of prejudice. But it also, there's language in there that I think it's important to take note of. It said the requirement for the description, quote, is sufficient if it describes the property so that it can be located by the exercise of ordinary intelligence, and so that more detailed information concerning it could be obtained if desired. That's what we have here. We've got a recording statute that requires parties to record their interests in real property, and we have the trust statutes that provide a description of the property. And there's a couple reasons we know that within the trust statutes themselves. First, if you look to ARS 33802, it talks about how you describe how you provide a legal description in a deed of trust, and it provides several methods for doing that. Meets and bounds, by reference to, it all has to do with the physical location of the property. It has nothing to do with the interests within the property. So we have within the statutory scheme itself how you do a legal description. Then when you look at the notice statute 33809, there's actually 3 different ways that you're required to describe the property. They don't take issue with 2 of them. You have to include the street address, you have to include the tax assessor's parcel number, and you have to provide a legal description. All of those go to the physical location and identification of the property, not the interests that may be held for that property. On the issue of the burden of proof, I think what they're arguing is that there was a failure of a condition precedent to bring the lawsuit, and that's their burden of proving a failure of condition precedent. They actually didn't assert it as a counterclaim. They didn't even assert it as an affirmative defense. All they did was file this motion for summary judgment. They didn't meet their burden. In fact, the evidence was the trial court and the record shows that the evidence was uncontroverted, that the notice requirement was met. Unless the court has any questions, I'll rest. Thank you.
Thank you very much.
Is there anything in particular the court would like me to address?
I would like to hear your response to the suggestion that your client did have an opportunity to submit an affidavit in connection with the motion for summary judgment.
He did submit an affidavit, and he actually did testify briefly at trial that he did not receive notice So there is evidence of that on trial. One thing I'd like to stress is Sage never cross-moved for summary judgment. They never asked for an order of relief or partial judgment or anything of that nature. Harrison moved for summary judgment, and that was denied. And after trial, Sage latched onto this argument that those became findings of fact and established conclusively that Sage was entitled to judgment and that they proved everything that they had to prove. All that happened was a denial of a motion for summary judgment.
Well, did the court not, as we've been told, then state at least on the two issues that were brought that there wasn't a genuine issue of material fact with respect to notice and description? Because the court can, in fact, on its own, resolve, the issues, narrow them, so that when there is trial, you only focus on what the court sees as the only remaining issue.
The court gave reasons for denying summary judgment. There's nothing written from the court establishing any change to the claims that were before the court or the defenses that were before the court.
But
Also,
I'm puzzling a little bit, though, over the same things that my colleagues are asking you, I think. When your client realized it was going to trial only in regard to the sale price and the deficiency amount, if the other side had failed to establish their compliance with these technicalities, why even have the trial?
to answer the question, we did not know that the trial was not going forward on the trustee sale issues until the day of trial. The parties prepared a joint pretrial. They stipulated in there that if the sale was valid, then the court was to determine the deficiency, the fair market value of the property. So up until the day of trial, we had recognized that there was a denial of a motion for summary judgment and that the issues were going to be litigated, and that's what the parties had agreed to litigate, until the point where we said that we were going to move forward and call the trustee at trial to prove our defenses, and that's when Sage objected and convinced the court not to allow us to call a witness that both parties had listed in the joint pretrial. So this was the very first time that Harrison learned he would not be able to challenge that term of the contract. So there is nothing to be done with a denial of a motion for summary judgment. A party's not required to put all their evidence in a motion for summary judgment. They're required to put forth what they think is enough to prove their case. And if the judge says that's not enough, the converse isn't true. The other side doesn't win the case. You move forward and you try the issues. And that's what happened here, what the record shows happened here up until the point that Sage decided that those became findings of fact, even though they weren't written.
And then apparently the judge decided that as well.
Well, the judge never decided they were findings of fact, because if you look at the judgment, Sage tried to get that language in there, that based on this denial, the court was entering judgment. And the trial court judge crossed that out. He said, no, we're entering judgment based on trial. And I think what happened was
Didn't the judge realize he was doing essentially the same thing?
I'm sorry?
He's doing essentially the same thing as finding those things. And somehow he or she was rejecting your defenses, or your argument that they haven't carried their burden.
My assumption is the judge was drawing from hundreds of other deficiency cases where the validity of the trustee's sale may not be an issue for trial. But in this case,
where the contractual documents are different.
Correct. Sage argued a lot about evidence that the trustee would have testified to. We find that a little bit ironic because we had asked to call the trustee to testify at trial, and instead they're relying on an affidavit that was presented that we never had an opportunity to challenge. So I'd ask the court to take that into consideration in thinking about the evidence that Sage is arguing about.
So at no time from the filing of the complaint through the trial was the trustee deposed?
The trustee was not deposed, correct. Really briefly, you had asked about a statute before. It was 33808E for invalidating a sale based on the legal description. And Sage just argued to you that a trustee is not required to identify the interest in trust property. That's directly in contradiction to the statutes. The statutes, 33-801-8, defines the trust property as an interest in property capable of being transferred. The interest in property, not the property, but the interest in it. And that's what the trustee had to put in the notice of sale. The fact that he did not describe the interest in the property invalidates the legal description.
Does it have to have does it have to have a real-life difference? Did it make, is there any reason to think it made a real-life difference, or are we to overlook it if we can't see why it might have made a difference?
Well, it does make a real-life difference because currently there are two deeds out on this property. Sage still holds its previous 50% interest, and there's a deed that shows 100% interest or doesn't limit it to a 50% interest. So there are inconsistent deeds that are currently recorded on the property. So it does make a difference as to the validity of the sale. Whether or not that prejudiced Harrison is irrelevant to the validity of the sale.
What's your response to their argument that there was expert testimony that it was actually less valuable? It would have been less valuable had they listed it with that interest.
The trial court didn't address that because it didn't consider the issue. So we don't know whether or not the trial court would have believed that testimony or accepted it. But we would think the common sense approach is the smaller the parcel, the more likely it is someone to buy and the more attractive it is.
And what's the basis of that opinion?
Well, I think the lower the price, the more likely it is someone can afford it.
Yeah,
And again, had
it's
this-
not a smaller parcel, it's a lesser interest in the same parcel, right?
You'd have to have investors who are interested in joining a partner who they may or may not like.
This is a point I would have loved to address at the trial court. Yeah.
Okay. Anything? Apparently, thank you very
And I
much.
have nothing further. Thank you.
Thank you. Oh,
We appreciate the argument of counsel. We will take this matter under advisement and issue our written ruling in due course. I think I know who's going to get it. We appreciate the argument, and we will stand in recess for the next matter. Thank you.
I'm sorry.
You guys, happy Thanksgiving.
You bet. Thank you.
Remind the gallery to please silence or turn off any cell phones. All rise.
Good morning, thank you. Please be seated. We are here in our cause number CV120849 involving Karen Pac-Man versus Michael Pac-Man. Hopefully I'm not messing it up too much. The time set for oral argument. Each side will have 20 minutes to argue. The appellant, if you'd like to save some of your time, will let you manage the clock. We are both audio recording and video recording. So as you come forward, please identify yourself and your client, and that will take care of that issue. We've read the briefs in this matter. We've conferenced this case. We believe we understand the issues, which really are essentially based upon two documents that the parties enter, one before the marriage and one during the marriage. And with that in mind, appellant.
Thank you.
Mr. Hinkle.
Your Honor, my name is Gregory Hinkle. I'm here with co-counsel Robert Sisko on behalf of Karen Packman, who is both the appellant as well as the petitioner in the trial court below. This court is quite correct in stating that it largely involves two contracts in this case. The interesting thing is that both parties heavily, very heavily negotiated these contracts, in some instances for 2 years. They are plain and unambiguous, and that has always been the position of Karen in this matter, and that the contracts are embraced by both parties, which means nothing involving, and I'm going to be referring to the prenuptial property agreement as the PPA and the memorandum of understanding as the MOU, if you don't mind.
We do that too.
And in this respect, all, therefore, equitable considerations that might otherwise be considered in a case arising in a domestic relations context are not here. Any unfairness or whatever that could have arisen, for example, under 25201 is gone because the parties say that's non-existent. Now, there is an unconscionability argument, which I will get to in a few minutes, which, of course, will be destroyed because it has no place in the law or in equity. The point being, these are contracts indistinguishable from a commercial contract, two of them. There are some complexities, but here is the most important thing where the court went in error. They are not contemporaneous contracts. They are 4.5 years apart. Most importantly, they are not in paramateria whatsoever. The PPA, which is designed to be, of course, prospective only with respect to the rights and assets of the parties in the marriage, was in December of 2003. It was only in April of 2008 that we get to the MOU. The MOU deals exclusively with the value and the creation of Harbor Heights, which had occurred during the marriage, in which it became a community asset. And that is extremely important to the court. It was retroactive to January 1st, 2008, 3 years before this marriage took place. And in that account, for example, this shows where the mistakes were started. In issue number 1, and I'm just using it as an example, the court stated the following. I basically had to say, notwithstanding they say X, X meaning the contracts, I'm going to have to read them to say Y, because otherwise it just doesn't work. That remark is the very antithesis of why we have contracts, which is to stabilize and have predictability and fix your legal rights. No equity here, legalities only. And this can be seen in issue 1, and it is put there as an example. You can determine the length of this divorce for purposes of the post-decree regular spousal maintenance, all of it. Just read 5.7, the preamble, and 5.7 D3. It states the calculation for the amount of months in the marriage, which in this case is about 99.7 months rounded off to 100 months. Well, now you know how much to apply under their formula, because they have mathematical formulas. And what's important here, This moves to the second issue, the joint account. Much to do has been made by the opposition that how can you possibly be giving both parties $108,000? Well, because that's what the mathematical formula says. Paragraph 4.3 of the PPA sets the joint account up and says that primarily it can be living expenses and so forth. Of course, in reality, what it was is Mr. Packman was running even business revenue and expenses through this one account, joint account of the parties, specifically envisioned ahead of time by the PPA. After the MOU was signed and Harbor Heights was a community asset, Mr. Packman, not Karen, started to put volumes of money through this account for whatever reason. It was his doing and his doing exclusively, and he put approximately $5 million into that account in the 2 years prior to the divorce being filed in this action. In those 2 years, under the MOU, the joint account, they specifically set up that in the event of a divorce, in these very circumstances, there was to be a funding of that account to continue. The very same account, by the way, there was a breach of this lease the moment that Mr. Packman.
Can I interrupt? Doesn't the MOU talk about the account being funded to pay living expenses, though? Doesn't that suggest that it's living expenses as opposed to?
It says much more than that, and it says only primarily. In other words, it's left open. It does mention that. But the point being, it's clear if you look at 5.7 that there's a mathematical formula, Your Honor, a very specific one that states you encompass the prior 24 months of funding in the joint account and subtract from it 3 different areas of separate property that may have been put into that account, and you come up with a fixed sum. Now, why would the parties do this? Well, easy. They wanted to have a formula that was extrajudicial. They didn't have to go to court. You sit with the very same account. You don't discontinue it like Mr. Packman did. The very same account.
At the time they set this up, was it the practice to run the business expenses through this account?
Well, I think the joint account came as a result of the PPA. I don't think it existed prior to that time, Your Honor. So its existence started back in 2003, and
So at least in this instance, you're saying we've got to both look at the PPA and the MOU to figure out that the court was wrong in its ruling.
Oh, no, you won't have to look at the MOU.
Okay? Just the PPA and 4.3.
The MOU's only involvement here was to convert Harbor Heights into a community asset. This is extremely important, Judge Portley, because when those funds were being put into this joint account after the MOU, they were already community assets. Therefore, the transmutation that the opposition talks about did not occur. It was already community property when it was put into the joint account. Large sums of money. Now, there is utter consternation by the opposition. Well, this is a lot of money. Well, I guess we'd talk to Mr. Packman about that. But the fact of the matter is, for every dollar that Karen gets, Mr. Packman gets $1. And isn't that fair given its community assets to begin with. Harbor Heights. This is coming from East Valley Pediatrics predominantly, as well as some other companies.
But do we look to the intent of the parties as to this particular provision?
You look to the mathematical formula in the contract is what you look for. It's really meant to be pendente lite support for her, and he can take an equal amount out for support for him during the divorce. Otherwise, there's no purpose to having the mathematical formula in the contract as written. You can gauge it down to the dollar how much it's to be by using that, and that was the point. Is there any ambiguity here? None. The only way that such volume of money comes about is by Mr. Packman. But yet, you will hear this unconscionability argument, which I find curious for several reasons. One, you cannot have unconscionability of performance. There's no such thing. You can have it as far as procedural in the formation of a contract, but the parties embrace the contracts here. That's gone. And as substantive unconscionability, which goes to the terms and conditions of the contract only. It has nothing to do with the performance. Well, what I mean by a mathematical formula is the fact that there's no figures in it. Those figures are provided by Mr. Packman's deposits of community assets and revenue in the joint account, to which she has a right. It's expressly in the contract. And therefore, with those deposits, no transmutation is occurring. It's a community account, and it's a community investment through that account. She gets $1, he gets $1. It's $5 million that's to be split. Then that accounting is to be taken into consideration because you simply take the average.
If he had not placed the funds in that account and run it through a business account, what would her entitlement have been to the asset as part of the business account?
Under some other provisions of the account, she may have been able to seek more money by trying to go with living expenses on a statutory basis. But I don't see where, for example, there could be real problems. If he was only putting in, for example, $5,000 a month, from which he would get $2,500 and she would get $2,500, that could be a problem, I admit. Of course, it's a problem we don't face here.
My question goes to what you're saying. This money went into the joint account, assuming it was a business expense, and he could have put it into the a separate business expense, or a business account. I guess the argument is it ultimately didn't result in that amount of money because it had to be paid to the business, so there wasn't a profit, so no one's actually entitled to the full amount of it. Is that why it makes a difference?
Yes, it's because it was run through this account, this specific account, which was not to be discontinued, Your Honor. Not to be discontinued. You have an interesting question. What would happen if a separate account had been made by Mr. Packman, which is only a hypothetical here? What if it was these revenues were run through that? There would be difficulty. There would be difficulty, but we do.
Yeah. What is in the record as to why Mr. Packman put so much money into this account during that?
I think it had to do with airline tickets, getting free airline tickets and other matters, but he was doing it consistently for some period of time prior to even 24 months. And the interesting thing is he was doing this month after month after month, knowing of the existence for the last 6 years of the PPA and the joint account and its ramifications. You do not get to be having a net worth of $30,268,000 without being a very astute businessman, in addition to being an excellent physician. $30,268,000. And I'm running out of time here, but that becomes very, very important for purposes of the attorney's fees. Her net worth, Karen's, is $169,000. The ratio is approximately 180 times the wealth in the doctor as opposed to Karen. I see I have just over 5 minutes left, and I would like to reserve it for rebuttal. Thank you.
Mr. Schwartz?
Good morning, Your Honors. Robert Schwartz. I appear here on behalf of Dr. Packman, also with my partner, Ann Tiffin. Let me address this joint account, if I could, and the argument that they make. You asked a very good question, and that was, what was the reason the money was put in the joint account? And the record in the case is very, very clear. The wife agreed to it in trial. The husband testified to it, and there were numerous exhibits that were admitted that the reason was because of substantial and significant annual rebates that were received by paying for these business expenses through the credit card on the personal account. The exhibits at trial demonstrate that rebates went from $18,000 a year to over $24,000 a year as a result of this money going into the joint account. So that was the simple reason it was done, to obtain these rebates on a personal credit card that couldn't be done through the business. And what would happen is the charges would be paid through the personal credit card, and the money from the business would get deposited into that joint account in order to pay those credit card charges. So there are a number of exhibits and evidence that establish these large credit card rebates. Secondly, you asked another question, Judge. When did this account come about? The record indicates very clearly this was a joint account that Dr. Packman had with his prior spouse who passed away, and he just kept the same account, and after marriage, he added Karen's name to that account. The record also establishes very clearly that Karen knew and admitted in court that this account was being used for business purposes. So when the judge made the finding on this account, he made a specific finding that he needed to look at the rules of contract interpretation and the express agreement of the parties, requiring the court to interpret the PPA as a whole according to its fair meaning. And that's what the judge did throughout this case. The judge concluded right at the beginning in response to our summary judgment request, which asked him, when you read these two documents, they don't make any sense. They use conflicting terms. They use decree. They use dissolution event.
Could we go to the first issue in terms of where it doesn't seem like there's much of a conflict if you just read the first document that talks about the entry of a decree. Why is that ambiguous?
Because the first
In terms of
document...
setting the number of months.
Are you talking about on when the spousal maintenance begins?
How many months it will last?
Because the judge, I think, in response to the summary judgment, right at the beginning of the case, there was an issue about how are we going to measure the starting point to the finishing point. There's no question that it's half the length of the marriage. The issue became, when do we end it for the purpose of determining the number of months? And the judge made a finding, number one, that the document was ambiguous.
But is the PPA ambiguous, or is it only ambiguous because of the MOU?
The PPA itself is ambiguous because the terms that it uses conflict with each other as far as timing. It uses, one second, it uses the term divorce date.
Dissolution date.
Dissolution date.
Dissolution event.
Dissolution event and dissolution date, and those terms are internally inconsistent with the document because they just don't make sense. It becomes even more difficult when you look at it with regard to the MOU. So what the judge did is the judge determined that the dissolution event was the filing of the action which terminated the community. And then he measured the timing from the beginning of the marriage to the dissolution event, which was the termination of the community, and it was half the length of those months. So we're talking about 47, I think 42 months versus 50 months. The dispute here is 7.5 months. That's the dispute that relates to that issue. But to answer your question, the document, in our opinion, and the court's opinion, was internally inconsistent and ambiguous. Let me just finish with the joint account, because they keep making this argument about transmutation. It's transmuted. I mean, that is what transmutation is. The deposits that went into that joint account, every time the money went into that account, it came from a transmuted asset. If you look at the MOU, it's repeatedly referred to throughout the pages, pages 2, pages 3, pages 4. It's repeatedly referred to as the husband's transmutation of separate properties into a community asset. And that's simply what the concept is. When you take separate assets and you make them community, you have transmuted them into a different form of an asset. And as Earl Secor, their expert, admitted in trial, every time a dollar went into that account that came from his prior separate assets, which are clearly defined in the PPA, that got transmuted to a community asset through the MOU, Earl Secor acknowledged that those were transmuted deposits and that he included them when he calculated this astronomical amount of money that the wife was claiming for temporary support.
Does it matter when this transmutation took place?
No, it doesn't matter.
Upon deposit versus saying that the husband's businesses were community property and starting it at that point, it doesn't matter at all, does it?
No, because the PPA clearly says exclude any transmutation or conversion of separate property into community property. That's language on page 7, paragraph 5.7a. It says right there, exclude those deposits when you make this 24-month calculation. It doesn't say exclude them only from the point that they were transmuted and not forward. I mean, this is an open-ended statement. So the answer to your question is no, it does not matter. It just is a look back. And why was that? I mean, it makes perfect sense if you think about it. The purpose of this account, and Judge, you keyed on it, I think, was to provide a temporary support stream of income for both parties to pay for their living expenses and their normal expenses. It wasn't to provide, as they're asking for, $90,000 plus a month as a windfall. This was, and it says that these funds are going to be used to pay temporary expenses. Something they completely gloss over and they completely ignore is the fact that this entire issue was settled by a stipulation. They make this argument in their reply brief that the court found the issue to be res judicata and that the stipulation that was entered in June is not controlling. Well, if you look at the stipulation that was entered in June, at the time that stipulation was entered, there were basically three things happening. Number one, there was a petition pending the wife had filed asking for temporary support. Number two, there was a dispute as to the amount of temporary support the wife should receive under the PPA and the MOU. And number three, there was an agreement that was reached in writing in this stipulation, which clearly reflects the PPA, the language of the PPA for the temporary division of that joint account, and the fact that the wife was going to be receiving half of $45,000 a month that the husband agreed to continue to deposit into the account in order to settle and satisfy this joint account issue. There was no reservation of rights by either party in that stipulation. And Judge Norris properly found in the order that that stipulation in June was controlling, that that stipulation settled this issue of
the issue of the amount?
Of the amount and the issue under the PPA, both. And as a matter of fact, he said, husband, you've been overpaying her. He made a finding that under the calculation, excluding the business expenses and the transmuted monies, there was only $32,000 that needed to go into that account. But the judge said, you know what? You entered into this agreement. You're both bound by it. So you agreed to put 45. You're overpaying her. You only got to give her 16. You're giving her 22.5. So that resolved the issue. They make an argument in their reply brief, well, all temporary orders are subject to review and are not binding. That's a totally erroneous and bogus argument because this was not a temporary order that was entered after a hearing, after testimony, and after the court made findings based on a controverted issue. This was a stipulation. And as we all know, parties are bound by their stipulations, and the court favors stipulations.
I thought wife's argument here on this particular point was that the amount in the stipulation, it was for the amount, not for when it started.
Well, that's the argument, but if you read the stipulation, it does not reserve that issue, as most people would have done if you wanted to later dispute it, and which I have done in almost every case where I want to save the issue. You say this stipulation is not binding on either party and may be reviewed at a later date or may be reviewed at the time of trial. The stipulation is very clear. It says it resolves the temporary...
Do you use language that says this, we stipulate, but it's not binding on anybody?
No, the language I use says that we stipulate that this issue is subject to further review and neither party is waiving any rights by entering into the stipulation. That's the language I use.
Doesn't sound like very much of a stipulation.
Well, it settles the issue from the time you enter into it to create a cash flow until you get to the ultimate trial, at which point you then say, Judge, look, now we're going to have a look back. I mean, that's something we do all the time in these cases because the most important thing is to get the cash moving. But this didn't say that. I mean, this stipulation is, I mean, it's a binding stipulation with no reservation of rights.
So, well, the difference you're trying to, at least, is that this stipulation seems to, well, your argument resolves the issue as opposed to just making it a temporary orders issue subject to future trial.
Exactly, Your Honor. And the judge found, even if that wasn't the case, that the claims the wife had made, I mean, you have to understand, because this comes to attorney's fees, she was claiming at trial that she was entitled to this temporary support under the joint account for the rest of her life. Even though the agreement is termed and talks in terms of temporary support to pay interim attorney's fees, that the purpose was during the pendency of the case. At trial, they were making the argument that she's entitled to, over $1 million a year under this provision for the rest of her life, in addition to the two other support streams that she was entitled to, the spousal maintenance under the PPA and the spousal maintenance under the MOU, which kind of jumps a little bit, but that is part of the judge's findings when he says parties were unreasonable in their litigation positions and did not award either party attorney's fees for disparity in income or positions taken on the trial issues. So the JCA it's a big dollar amount, but it's really so far overreaching beyond the intent of the parties, beyond the mathematical calculation, and trying to totally ignore a binding stipulation that resolved the issue. Let me, if I could, unless you have any other questions on that, I'd like to address something else. And that is this issue of the standard of value. So what happened here is Linton Kotzen, who was retained to do this appraisal, came to court, and he says, and the trial transcript, we've quoted it to you, the trial transcript is very clear in Mr. Kotzen saying to the judge, look, I've done two standards of value. I've done investment value, or sometimes you will call it fair value, and I've done fair market value. And my preference is investment value, but it's up to you, Judge, to decide which standard of value to use. And then he says to the judge, the reason I did one versus the other is this indemnification. And the indemnification that Dr. Packman gave to Karen when they had this apartment house they bought, where he agreed to indemnify on a loan. And the testimony at trial was uncontroverted that indemnification was staying with the wife. And that's the reason the judge, in his discretion, and that's the key, the discretion of the judge, because you have told us now for years that the issue of standard of value is a question of fact dependent on each case. I mean, we can talk about the Walsh case, we can talk about the Kelsey case, we can talk about the Mitchell case, and you have told us time and time again that the question of standard of value is a case-by-case determination to be made by the trier of fact. So what happened? The trier of fact...
You're expecting us to be consistent, it
No,
sounds like.
no. I've been here a few times. So. The trier of fact was told by the expert.
We actually do try.
Believe me, I understand.
Go ahead.
Excuse my humor. The trier of fact was told by the expert. You decide. Here are the facts. You decide. But let's take it a step further. Not only was the expert telling the trier of fact, the judge, to do this, but the wife's attorney told the judge, that's exactly right. I'm going to paraphrase, but we gave you the quotes, where the wife's counsel says to the judge, that's exactly right. You have to decide. That's all you have to do. Uses words. That's all you have to do. You decide whether it's investment value or fair value, and that's it. And we're stuck with it. Well, the judge, to his credit, and I think it shows Judge Norris's background because he was a bankruptcy litigator for years, he went through a very detailed analysis in his findings of fact as to why he felt fair market value, in his opinion, was the proper standard to use. Well, I submit to you that there is no abuse of discretion. It's not a de novo issue. It's exactly what the court was asked to do. But more importantly, again, when you invite a judge to do something in open court and you say to the judge, this is the issue that you need to decide, and whatever you decide is binding on us, and the judge does it, and now we come up here and scream, the judge did what I asked him, but I don't like what he did. That's in essence what we're here about. So I don't see where there's even an argument for reversible error by Judge Norris. Mr. Kotzen clearly placed it in his ballpark, and the judge did exactly what he asked him to do. There's another interesting argument that the wife makes, which is, okay, I understand I had to sell the business to my husband as of the valuation date that we agreed to in open court, but even after he paid me for that business, I still want distributions from that business. Well, I don't know too many people in the world that would go out and buy a business and then tell the seller who got paid for it, you can come back and keep putting your hand in the cash register whenever you want and just keep taking money. And that's exactly what the judge said. In response to the argument, hey, you know what? You're not getting continuing distributions because it's clear under the agreement that contemplated while you both still own the business. Your husband paid you for the business. He bought the business. As of that date, he owned the business. So those distributions stop. It's just kind of logical. Let me address, I'm almost out of time, the last issue that I'll address, and that is the spousal maintenance termination. Under the MOU, the court found that spousal maintenance, the spousal maintenance stream to pay the wife, terminates on the death of the husband or the remarriage of the wife. Well, they make an argument, because the MOU says for the rest of her life, that that can't happen, that the judge abused his discretion in making that finding. And we cited to you in our brief, on pages 46, 7, and 8, and 9, we cited to you cases that deal with this express issue. And I'd like to point out to you the following. The cases that have come out of this court, Division 1 and 2, have consistently said on this issue, say what you mean and mean what you say, and don't leave it subject to speculation. If it's subject to speculation, then it's subject to interpretation and modification.
Doesn't this just say in the event of the wife's death?
I'm sorry?
Isn't the provision here just in the event of the wife's death, the payments would stop?
Yeah, but it's silent as to the husband's death, and that's what these cases are saying. Because, and the court made the following finding. The court said, as Mr. Hinkle said, hey, you negotiated this agreement for 2 years. You both had lawyers. You went back and forth. The testimony at trial that the court believed from the husband was that this provision on his death was intentionally left out of this agreement, but it was covered in the PPA by requiring life insurance. And the court concluded, I believe, and I submit properly, that because there was no language about the husband's death in the MOU, and because there was no provision for life insurance in the MOU, and based on the statute 25327, that...
Sorry to interrupt, but isn't this different, though? Isn't this supplemental maintenance based on transference of an asset?
Well,
So there would be less need to have a life insurance policy? It's kind of consideration for the transfer of the asset? Is that their argument?
I'm not really sure what their argument is because I've read it a few times, but I think your question is better than their argument. And that is, the answer to that is no, because there's no minimum payment required in this document. And if that was the case, the document
It does require it until her death.
No, there's nothing. In the MOU, there is no minimum payment required for her interest in Harbor Heights. If she died the week after the decree was entered, the husband went over, ex-husband.
Right, but if she doesn't die, I mean, if he dies the day after the agreement's entered, doesn't it make more sense to interpret it as part of the property settlement, and this was to be given to her? There's still this asset, so that the fact that you haven't bought a life insurance policy seems to me neither here nor there.
Well, that would be true if there was a minimum payment required by the husband. But there is no minimum payment required by the husband. There's nothing that says in here that if husband should pass away, as it says in the PPA, that if he passes away within the first 5 years, 10 years, 2 months, that he has to pay this amount of money. And the cases are all very consistent, that if you have to speculate about what it means, then it's subject to 25-327, and it's subject to interpretation. And the court properly found that it was terminable on the husband's death because no provision was made for it. And again, the standard there needs to be an abuse of discretion. The court had in front of it testimony about this exact issue. I see I'm out of time.
May I ask a question, Your Honor? Is it really spousal maintenance? I realize it's called additional spousal maintenance. I think that's the term used. But is it really spousal maintenance, or is it really part of a property settlement?
It's spousal maintenance because they created it as spousal maintenance and they made it a taxable event. And it would be treated by spousal maintenance by the IRS, and it would be treated by spousal maintenance by this court. If they didn't want it to be spousal maintenance, they would have called it property settlement. I mean, if you want to look behind the agreement for the purpose of the payment, that's inconsistent with what the agreement says. They created a specific provision to make this a taxable event, and also by making it spousal maintenance, don't forget, it became enforceable by contempt. A huge, huge remedy, which is what they both apparently bargained for, because if it wasn't spousal maintenance and it was only a property settlement, it could be discharged in bankruptcy. You couldn't enforce it by contempt, and it would be a whole different series of obligations. So the answer to your question is, yeah, we could speculate as to what it was, but they both agreed as to how they wanted it to be characterized, and probably for tax and enforcement purposes.
By using the words spousal maintenance, then you invoke the potential application of 25-327.
Oh, you definitely do, because 25-327 controls, and that's our argument in our brief.
Thank you.
Thank you very much.
Thank you, Your Honors. You will note first that immediately the opposition through Mr. Schwartz starts talking about exhibits and testimony, and they have to do this because they don't want to live up to the language they agreed to. It's as simple as that. And this goes to address the question, Judge Cantini, that why would you use dissolution event in the MOU contract to apply to the PPA that answers it in 5.7 clearly, that it is a decree coupled with the property settlement agreement that takes care of the matter?
Is the language in the PPA that's talking about the decree, is that only going to when spousal maintenance begins, or does that talk about?
That is talking about the length of the marriage, which, as I was saying, is 100 months because it tells you when the end of it is. Everyone knows the beginning is the date of the marriage, December 20th, 2003. And then the end of it, April 9th, 2012. You got 100 months. But that's the end of it. This is a classic example that you don't need to be going to the MAU about the PPA. This started the confusion in the first place. But you don't even need the exhibits for the first 5 issues. The same thing applies to those next 4 issues. Now as to the joint account. All you have to read is paragraph 4.3, which is important, and it's not limited as to what can be put in there, and read it in the context of 5.7 as well. And you will get the whole picture of what this joint account is about. And that is, they may say that account existed previously, but believe me, it took on a new wording and governance through this contract when it was once signed on December 17th, just 3 days before the marriage. Because it now states that the transmutation they're talking about, for example, in 4.3, is when you deposit it. It doesn't mention anything else. That's the only thing that would make sense since you're directing the language towards the account only. Under their theory, if you were married for 40 years, we transmuted this, dear, 39 years ago, if you'll recall. So those deposits would not matter in this? Of course not. But if you look at 4.3, it becomes obvious. You can't use the trick of the opposition to somehow make it retroactive. If it was separate property when it was deposited, that's a transmutation, and that's exactly what 4.3 says. It's not if it's already community property, and it's clear and unambiguous. Now, as to the res judicata issue on an interlocutory order, this is a first. First of all, no less than 14 times does the stipulation and the order declare it's temporary. There was no stipulation. There was nothing beyond just stipulating to an amount for pendente lite support of 22.5, which would be taken away from the amount of the deposits we are discussing, obviously. She doesn't get double paid. And in that regard, it simply would state that the 22.5 would be a temporary arrangement. 14 times it said this. You will be able to answer the question by statute. Please look at 25.315F. You cannot affect substantive rights in an interlocutory order. Has anyone ever heard of applying a res judicata doctrine to an interlocutory order? I don't know of that.
Parties can, in fact, enter into stipulations that survive interlocutory orders. And we'll have to resolve that, obviously.
Next, Your Honor, on the appraisal, they'd love to make this abuse of discretion. No. It is a mistake to state that Mr. Kotzen ever approved standard fair market value. He never, ever did. On page 14 of the reply brief, you will find approximately 8 citations to Mr. Kotzen being consistent with his report that it is the investment value. And why? It says you are to value Karen's HH interest, meaning Harbor Heights. It doesn't mention a sale. In the whole paragraph 2M, which is very lengthy and very considerable, there's never a sale mentioned. That's because this is static. This is being evaluated in her hands, not its value to be sent to a third party. Not in the doctor's hands at all. Just value her. If it was to read as they said, and by the way, there is no stipulation to the contrary here. The only stipulation was you're still subject to the contract. The only stipulation is that it was going to be, I believe, if I recall, the only stipulation in the joint account, in the appraisal, was as to the matter of conforming to the contracts. Excuse me for that delay. Conforming to the contracts. There was no stipulation otherwise. They have no right. And by the way, my last remarks are this. The contract would have to state something like this in order to prevail on this idea that they were to extract the indemnification. It would have to say Karen's HH interest minus the indemnification because it has considerable value. To merely mention fair market value by Mr. Kotzen is not the same as his approving it. On that basis, Your Honor, I conclude my remarks.
Thank you very much.
Thank you, Your Honor.
We appreciate the argument of counsel. They've been helpful. We will take this matter under advisement and issue our written ruling in due course. We stand adjourned. Thank you.
Bob, nice to meet you.
Bob, nice to see you. Take care. Hi, Bill. Take care.
Oh, you can leave it on the table. I'll take care of it. Thank you.
All right, thank you.
You're welcome.
Okay.